The Second Amendment to the United States Constitution, ratified in 1791 as part of the Bill of Rights, states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." This concise yet powerful statement reflects the Founding Fathers' intent to secure individual and collective rights related to firearm ownership. The historical context stems from the colonial experience where an armed populace played a crucial role in the struggle for independence. Concerns about standing armies and the need for a militia influenced the drafting, with the framers aiming to empower citizens to protect themselves and their nation. This foundation has sparked enduring debates about the scope and interpretation of the right to bear arms. Originalist interpretation of the Second Amendment adheres to a strict constructionist view, emphasizing the framers' intent at the time of drafting. Originalists argue that the language, context, and historical understanding of the late 18th century should guide the interpretation. They often stress the importance of the militia cause and the individual right to self-defense. In contrast, the Living Constitution interpretation sees the Second Amendment as adaptable to contemporary circumstances. Advocates argue that the Constitution's principles should evolve with societal changes. This approach might consider the amendment's broader purpose, balancing individual rights with public safety concerns and adapting to modern challenges. The tension between these interpretations underpins debates over the extent of gun rights and regulations in the United States. The individual rights versus collective rights debate within the context of the Second Amendment revolves around whether the right to bear arms is an individual entitlement or a collective duty tied to militia service. Individual rights proponents argue that the amendment guarantees a personal right to self-defense and firearm ownership independent of militia service. They emphasize an individual's autonomy and the importance of self-protection. In contrast, collective rights advocates contend that the amendment's primary focus is on the collective defense through a well-regulated militia. They argue that individual rights must be understood in the context of serving the broader community's security interests. This ongoing tension between individual liberties and communal safety shapes contemporary discussions on gun regulations and constitutional interpretation. Historical perspectives on gun ownership in the United States trace back to its colonial origins, where firearms were essential for self-defense, hunting, and community defense. The frontier experience and the role of armed militias during the Revolutionary War further embedded a culture of individual gun ownership. Fast forward to the present, and the U.S. has one of the highest rates of civilian gun ownership globally. The current state of gun ownership is marked by a diverse landscape, with varying regulations across states. The debate over Second Amendment intersects with issues like self-defense, sport, and cultural traditions, contributing to a complex and evolving discourse on the rights and responsibilities associated with firearms in contemporary American society. Landmark Supreme Court cases have significantly shaped Second Amendment jurisprudence. The 2008 District of Columbia v. Heller decision affirmed an individual's right to own firearms for self-defense, while the 2010 McDonald v. Chicago case incorporated this right to the states. These rulings clarified the individual aspect of the right to bear arms, influencing subsequent legal debates on gun control measures. Legal discussions often revolve around finding a balance between protecting individual rights and promoting public safety. Challenges arise when implementing regulations to prevent gun violence while respecting constitutional liberties. Striking this balance involves nuanced considerations such as background checks, restrictions on certain firearm types, and red flag laws, fostering ongoing legal debates on how best to reconcile individual freedoms with the collective need for public safety. Before we go any further into this deep dive into U.S. gun rights and the Second Amendment, let's look at what some of these words mean. Sources are in the comments. Militia, as defined by the Oxford Dictionary, is a noun. It means a military force that is raised from the civil population to supplement a regular army in an emergency. And it also means a military force that engages in rebel or terrorist activities in opposition to a regular army. The historical meaning is this in the U.S. All able-bodied citizens eligible by law to be called on to provide military service supplementary to the regular armed forces. This would appear to limit a militia to only two categories: working for and with a regular armed force and working against an armed force. Which category do you think the framers were referring to? Next, we'll examine the meaning of the phrase, the people. Who are they referring to? The Constitution includes the phrase, the people, 7 times, 5 of which are in the Bill of Rights. The Supreme Court commented twice on this phrase's meaning, but the two analyses aren't in agreement. In 1990, the court said that the people refers to those persons who are part of a national community. The touchstone was not citizenship, but the extent of an individual's connection to this country. In 2008, the court suggested that the term "the people" refers to all members of the political community, which might be interpreted to mean eligible voters. This interpretation could preclude foreign students, those on work visas, or undocumented immigrants, and citizens who cannot vote, such as minors and felons. A few lower court opinions indicate that this interpretation is possible. Considering the Supreme Court's confusing opinions on who the people are, the Constitution and all of its rights it bestows might apply to everyone, including felons and undocumented people, as well as children. Thus, immigrants, children, and felons would have the right to own firearms and vote, or it might mean the people excludes certain individuals who aren't eligible to vote, which would preclude constitutional rights being bestowed upon children and immigrants, such as the right to life, liberty, and the pursuit of happiness, as well as those under the Second Amendment. This confusion confounds lawmakers. Next up, what does free state mean? A well-regulated militia being necessary to the security of a free state. What is a free state? There is ample evidence about the original meaning of the term. Free state was used often in framing era and pre-framing writings. Those sources give us a clear sense of what the phrase meant at the time. In 18th century political discourse, free state was a commonly used political term of art, meaning free country, which is to say the opposite of it, despotism. Political theory of the era often divided the world into despotisms and free states. Free states had certain properties and were susceptible to threats of reverting to despotism. Free state security refers to protection against invasion, insurrection, and civil unrest. If despotism is the opposite of a free state, then what does that mean? It means the exercise of absolute power, especially in a cruel and oppressive way, and refers to a country or political system where the ruler holds absolute power. Some other words that mean a similar thing are tyranny, dictatorship, oppression, totalitarianism. Two examples of countries that have a dictatorship model of political power are North Korea and Venezuela. In the context of the Constitution, when the framers referred to a free state, they were referencing countries that were not ruled by a tyrant. To keep and bear arms means to own and carry weapons. On December 15, 1791, when the Second Amendment to the Constitution of the United States was ratified, or made official, the firearms at that time consisted of the single-shot musket. The military also had cannons which weighed between 6,000 and 8,000 pounds and fired a ball weighing from 28 to 60 pounds. Obviously, that was not a weapon an average person would own. In 1791, the majority of Americans viewed rifles as essential for farming, hunting, or trapping. Nearly every household owned one. Loading, aiming, and firing a gun was a complicated process that took about 30 seconds per shot. You simply couldn't do it effectively without training and practice. Shall not be infringed. Infringe refers to encroaching on a right held collectively by the people as a sovereign body, like a free state or country that was not ruled by a despot. In the Constitution, abridge refers to individual rights. For example, in the First Amendment, the framers used abridged when prohibiting Congress from curtailing a private right to freedom of speech. This means the Second Amendment has nothing to do with an individual's right to own a gun. It unambiguously refers to a public, not private right. In simple language, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, might be worded this way: a well-controlled and supervised conscripted army being necessary to the security of a democratic government at a local or national level, the right of that public government to own and carry arms shall not be taken away. The Second Amendment appears to refer directly to military readiness to protect the United States. But even if it is interpreted to mean each individual's right to own and carry arms, did the framers anticipate the types of weapons we have today?